Good evening, everyone, and welcome to another Sex Matters webinar. I'm Helen Joyce, the Director of Advocacy at Sex Matters. Our topic this evening is our proposal that we've put forward for amending the Equality Act. Clarify the meaning of the protected characteristic of sex. You're probably aware that we launched this proposal as a petition on the Parliamentary Petitions website about 6 months ago, or just short of, and we got tens of thousands of signatures almost immediately, and then a steady flow continuing of signatures until on International Women's Day, March the 8th, J.K. Rowling retweeted the petition link and said that it was a very important proposal. And bam, within just more than 24 hours, we got the last 15,000 signatures that we needed in order to reach the 100,000 mark. That means our petition will be considered for debate in Parliament. We're now expecting that to happen sometime after Easter. So this webinar is going to be a slightly different balance than we usually do, because our aim is to go into quite a lot of detail, some of it rather technical, to explain precisely why this is our strategy, how our amendment would work, why we chose to do this, and what we think it will achieve. I've got Maya, our Executive Director, with me, and she's going to start a slideshow and then hand over to Naomi, who is our Chair, and then she'll hand back to Maya to finish the slideshow. So quite a lot of people submitted questions when they registered for the webinar, which is incredibly helpful for us because we fed them into the presentations. So I think a lot of the questions people had will be answered during the presentation. But you can still put in any questions that arise for you while you're listening in the Q&A during the webinar. And we'll try to get to some of them at the end. But as I say, this is mostly going to be quite a technical presentation. But we will download them and we will use them to continue with our thinking, with our communications and with our strategy. We're going to finish bang on 8:30 p.m. and the recording will be available on our YouTube channel shortly afterwards. All right, Maya, over to you to start the slideshow.
Thank you, Helen. So this is the petition wording, which hopefully many of you will have signed and had your friends and family sign. I checked just before we went live and there were 107,238 signatures on the petition. So we're number 4 in the petition charts. And that means we should get a Westminster Hall debate on this after Easter. The Westminster Hall debate doesn't make decisions, but it's a chance to have the arguments heard. The aim of the petition is to clarify the meaning of sex as it relates to sex discrimination in the Equality Act. And underlying it, this is the proposed wording of an amendment that we think will do that. It's not in the petition because there is a word count limit on what you can put in a petition, but it's in the briefing that's on our website and that people have been sending to their MPs. The idea is that we would, that the government would insert this wording into the Equality Act in the section that has all of the definitions. So where it defines man and woman, it would add this alongside that. And it would do that using a statutory instrument, using the powers that are available already under the Gender Recognition Act. So it's a surgical intervention into the Equality Act. And so what the wording says is that in this act, references to female persons and women also refer to a person who was born female and has acquired the male sex under the GRA 2004, and do not refer to a person who was born male and has acquired the female sex under that act. And then the section underneath basically says the same thing, vice versa, for male people. What that means is that a trans man is protected from sex discrimination because of being female, and a trans woman is protected from sex discrimination because of being male. And having a gender recognition certificate doesn't change that. And the wording that we have here was devised together with people who draft legislation, and it seems like the simplest, clearest way of doing that and inserting that into the definition section of the Equality Act. What it makes clear is that none of this is changed by a gender recognition certificate. And we've thought quite hard about how to do this. our legal strategy. And what we wanted to do is share this thinking with you. And so these were the 4 tests that we applied when we were trying to come up with a proposal. That it must protect everyone's human rights, that it must be politically feasible, and by that we mean we want something that can be done by this government. It must go a significant way to solving the problem of the Equality Act and misunderstanding of the law being used against women and against single-sex services, and it must simplify the law and make it clearer to understand and for people to use. We also have thought about the unintended effects that this change might create. What are the risks? What are the harms that it might cause? What is the risk of doing this instead of doing something else? We've sort of thought about it like a game of snakes and ladders and tried to map out where the ladders are, where the potential snakes are. But the one test that we didn't set for ourselves was that this has to solve everything all at once. It doesn't do that. So this is our legal framework, our strategic framework for thinking about the whole problem. There are 2 immovable facts. Firstly, there are only 2 sexes. Sex is binary and immutable, male, female, man, woman. That's material reality. And then secondly, everyone has human rights. Human rights are universal, inalienable, and indivisible, as they say. You can't take people's rights away from them. And they're secured by the rule of law. So everything that sits in between material reality and everyone's human rights has to be consistent with those 2 immovable facts that can't change. The laws, regulations, policies, words, and the way those words are understood. So what we want is to fix that bit in the middle, to create a legal framework that's coherent, consistent, and respects everyone's rights. It's not a lot to ask. It's the basic minimum. And Section 3 of the Human Rights Act says, so far as it's possible to do so, legislation must be read and given effect in a way that is compatible with the Convention rights. And this is basically what we're asking for. What that means is that where there's language in laws or policies that's ambiguous, it must be read in line with human rights. Governments do get to decide how to limit people's human rights when they come into conflict, but what they can't do is destroy people's human rights by accident, by misunderstanding words. So this is currently what we have. It's a mess. And it's a mess that no one understands and that does result in people's human rights being constrained and destroyed because words are not understood. So when we started to develop this proposal, we mapped out all of the laws that talk specifically about sex. We looked at the common law definition of sex and the Gender Recognition Act and how that changes it. We looked at the Equality Act and the way it deals with sex discrimination, gender reassignment discrimination, the exceptions to both of those, and then also the statutory codes of practice which sit on top of the Equality Act. And then we also looked at other areas of legislation that don't specifically relate to sex in their top line. You know, they don't define sex, but they use that information. So data protection laws and safeguarding laws and policies. And all of these laws need to talk to each other and need to work consistently. And currently they don't. The reason why we decided to go in with the Equality Act is it's so important because it's overarching. It relates to almost all of these other laws. And so getting it clear in the Equality Act will help to get it clear in all these other areas. And this is how we think it should be done or can be done, is by using human rights. Misuse and misunderstanding of the human rights framework is how we got here. and using it as a tool is how we think it's going to be solved. So what I'm going to do is talk you through our human rights framework and then pass you over to Naomi, who will talk about the game of snakes and ladders that got us here into this mess. And then I'll talk about the amendment again. And as Helen said, hopefully that will answer most of the questions that we've received so far. But if there are others that come up, put them into the chat. So this is our human rights framework, and we published it. It's on the website. It's based on the European Convention of Human Rights, but it also works with the UN convention, the UN whatever it's called, declaration. That's the word I was looking for. The UN declaration or other regional human rights agreements and treaties, but we've gone with the European Convention and its numbers, and that still applies in the UK even after Brexit. Human rights don't tell people what to do. They don't tell governments what to do. They mainly tell governments what not to do in order to protect the minimum freedoms which allow people to live their life in peace and security. And the ones that we think are most relevant to the sex and gender wars are these 6. So Article 3, freedom from torture, inhumane or degrading treatment, and that includes being forced to strip, being forced to undress, particularly with members of the opposite sex. It includes forced sterilization or having any kind of body modification that's not done with consent, and obviously sexual assault. Then Article 8, respect for private and family life, that includes your personal information, your personal identity, your right to decide who comes into your sphere of interaction with other people. It also covers family life, so parents and children and their privacy from the state. Article 9, freedom of thought and belief, that one is very close to my heart. It includes religious belief and non-religious belief, as we know, and the gender critical belief. Freedom of expression, that includes freedom of speech, but it also includes the right to receive information, and it also includes other sorts of expression. So, wear what you please, and so on. All of that comes under freedom of expression. Freedom of association, the right to meet with people you want and form groups with the people that you want. And then Article 12, the right to marry and found a family. Those are really the 6 that matter for us, and also have been used in the development of law around trans rights. Some of them are absolute and some of them are qualified. So the ones with the asterisks are qualified, which means that they can be limited by laws. It's, the freedom to swing your fist ends where my nose begins, and sometimes the government has to step in to protect that. Alongside those specific rights, there are also a set of articles which are very important, which are about how rights are balanced, and particularly how rights are balanced where they are qualified. And there are 3 articles which are very important to this. Article 14 is about non-discrimination. Everyone has equal rights, regardless of their sex, their race, colour, language, religion, or other status. It doesn't say transgender here, but it has been interpreted to include that. And it's right that it should, because what it says is everyone has equal rights, regardless of their status. And quite often we get hung up on what is the definition of trans, what is the boundaries of trans. But when you're thinking about it in terms of human rights, it doesn't really matter, because what Article 14 says is everyone has equal rights. So if someone calls themselves trans, they have the same rights as someone who doesn't call themselves trans. They shouldn't be discriminated against because of that. There's no need to have some people inside or outside of the overall protection. Then Article 17 it doesn't actually say no one's rights go in the bin, but I was looking for a picture. It's that no one's, the rights that are given under, or that are protected under the convention don't mean that you can destroy other people's rights. This one was also important in my case. And this means that because someone has equal rights because they're trans doesn't mean that anything that they can do to protect that can be allowed to destroy other people's rights. That's important. And then Article 18 says that limitations are limited. So the government can limit your expression of your human rights, but it can't do that in a blanket way. Those limitations have to be for a particular reason and not applied for other purposes. So those three set the terms by which all of the other rights get balanced when they come into conflict. So now I'm going to hand over to Naomi, who's going to talk us through the game of snakes and ladders and how we got into this mess.
We talk a lot about how the law defines sex. And it's true that the law can define what it means by a word. The law can make a wholly technical definition of a word that is nothing like its natural meaning. But the law can't change reality. Sex is about bodies. Human bodies come in two types: the type that is configured for bearing children and the type that is configured for begetting children. So sex isn't about paperwork. It's not a legal or an administrative fact. It's a biological one. In 1971, the High Court considered whether a person can change sex in law by having sufficiently radical cosmetic surgery. That was a case called Corbett and Corbett. It was about whether a marriage between two men could be valid if one of the men had had his body sufficiently extensively remodelled. The judge said no. Sex is about genes, gonads, and genitals, and it can't be changed by identity or medical intervention. The Sex-Discrimination Act was passed in 1975. That was part of the original suite of discrimination legislation. The Race Relations Act, the Sex-Discrimination Act, and the Equal Pay Act, all passed in the early 70s, early to mid-70s. The Sex-Discrimination Act uses words, or used words, like man, woman, male, and female in their natural meanings. It didn't define them, didn't purport to define them. It did say a man means a male of any age and a woman a female of any age, but that wasn't about confining the words to their biological meanings, because at the time no one would have dreamt of anything else. It was just so that the Act didn't have to keep saying or girl or boy in all the places where it was appropriate to incorporate protection for young people as well as adults. So, to state the obvious, the Sex Discrimination Act didn't invent sex either. Sexual intercourse began about 385 million years ago. The Sex Discrimination Act took aim at a social problem. Why that social problem was widespread discrimination against women, and it assumes the meaning of woman. It assumes that that meaning is obvious. That now seems quite innocent, now that it's fashionable to pretend that one doesn't know what a woman is. But at the time, nobody doubted it. So the basic idea of equality law, the whole of equality law, is that discrimination is a bad thing. Arbitrary discrimination is a bad thing, except when it's not. And that really boils down to except when it's not arbitrary, except when it's for good reason. But sex discrimination and discrimination law generally leaves quite a lot of life completely alone. We're all of us free to discriminate in our personal lives. That's not because the law gives us permission to do so. It's because it has no business interfering in our personal lives. We choose for ourselves who we associate with, who we make friends with, who we marry, and so on. And also socially how we treat people. We may behave badly. There may be social sanctions for behaving badly, but we're not required not to discriminate in our social interactions with people. And that's as it should be. Discrimination is prohibited in certain specific interactions. So interactions like those between employer and employee, between service provider and service user, between educational institutions and students or pupils, between landlord and tenant, and so on. But even in those situations, there are plenty of specific factual circumstances in which discrimination is perfectly proper. And there was an extensive scheme of exceptions written into the Sex Discrimination Act from the outset to make sure that it didn't accidentally prohibit necessary discrimination. So, for example, in the workplace, there were occupational what were then called genuine occupational qualifications that made it possible, for example, to restrict your posts of bra fitter in a department store to women. There was a very broad exception in sport, creating a general right to separate events in sports where men have a natural athletic advantage, or where their natural athletic advantage is going to give them an unfair competitive advantage in that sport. And in services, you can exclude men from women's toilets, changing rooms, domestic violence shelters, and so on. And all that was written into the Sex Discrimination Act from the outset. When the Sex Discrimination Act had been in force for nearly 20 years, things got complicated. In 1993, a trans-identified man brought a discrimination case, which went to the European Court of Justice. He was referred to as P because he was anonymised for the purposes of the proceedings. P's employers dismissed him when he told them that he was going to transition. The tribunal found that the Sex Discrimination Act only provided protection from discrimination on grounds of sex, that is to say, whether you're male or female, and he therefore wasn't protected by the Sex Discrimination Act. But the European Court of Justice, when the case reached that level, gave the Equal Treatment Directive a wider meaning. Gender recognition discrimination, the ECJ held, was within the broader meaning of sex discrimination under the Equal Treatment Directive. And that meant that at the time, UK law was required to conform. As a result, in 1999, the Sex Discrimination Act was amended to add gender reassignment as a new protected characteristic. That new protected characteristic didn't affect the meaning of sex. And like all law, as Maya mentioned earlier, the Human Rights Act says that that must be interpreted so that it respects everyone's human rights. Trans rights campaigners at the time weren't happy with this development. In their terms, the protected characteristic of gender reassignment was a snake, not a ladder. It took them further away from their goal of forcing everybody to treat or accept trans people had literally changed sex. After P&S and before the 1999 regulations came into force, employment tribunals had already been interpreting the Sex Discrimination Act to give protection from gender reassignment discrimination. And campaigners for trans rights wanted to leave that situation as it was. Press for Change and others actively campaigned against the new characteristic. So why weren't they happy? Well, the problem from their point of view was that a specific characteristic makes it possible to write in specific exceptions. The Sex Discrimination Act said that men and women should be treated equally in the workplace, except where a particular job called for a man or a woman for reasons like privacy, decency, safeguarding, artistic authenticity, and so on. But the Act now dealt separately with the protected characteristic of gender reassignment, and exceptions were provided to that too in a similar way. And that, I think, was the problem. The statutory scheme of exceptions recognised that other people have rights and interests too. The new characteristic of gender reassignment meant that sex was kept separate. A transsexual male, someone who calls himself a trans woman, is a man with the protected characteristic of gender reassignment. So the activists didn't give up. And in 2003, Christine Goodwin won a case in the European Court of Human Rights against the UK. Goodwin's case was based on two rights: the right to marry and found a family, that's Article 12, and the Article 8 right to privacy. The specific privacy problem for Goodwin was that if he was asked for a birth certificate in dealings with his bank or his insurance company or something of the sort, that would reveal his sex because his birth certificate was unchanged. The European Court said there was no concrete or substantial hardship or detriment to the public interest from allowing people to change the sex on their birth certificate. The court didn't think very hard about the impact that this might have on women's rights. It said this: society may reasonably be expected to tolerate a certain inconvenience to enable individuals to live in dignity and worth in accordance with the sexual identity chosen by them at great personal cost. The part of society on whom the inconvenience falls turns out to be women. Who would have seen that coming? Following Goodwin, the UK brought in the Gender Recognition Act, which enabled people to change sex, quote, for all purposes, unquote. There's a curious bit of drafting in the Gender Recognition Act there, because it says at section 9(1), I think it is, for all purposes, and then almost immediately in the same section it says except where there are statutory words saying the contrary. So there is the option built into the Gender Recognition Act to disapply it from any context in which it needs to be disapplied. The exceptions that were built into the Gender Recognition Act at the time reflect some thought for other people's rights and interests. So there was a very broad exception for sport. There was an exception that meant that a woman couldn't bump her younger brother from inheriting the dukedom by getting a gender recognition certificate. There was a weird wrinkle at the time that the Gender Recognition Act came in that a provision was specifically written into the into the Sex-Discrimination Act to make it impossible to exclude a gender recognition certificate holder from a sex-restricted job for the opposite sex at all. That strikes me as quite bizarre and quite extreme. If you think of the example of a bra fitter in a department store, it would mean that someone who had a man who had no modifications to his body at all, didn't present in any way like a woman, but had a gender recognition certificate, would have been entitled to insist on not being excluded from that sort of job. And that was the case after the Gender Recognition Act and until the Equality Act came in. The Gender Recognition Act included Section 23, which gives the Secretary of State power to make an order creating other exceptions. This is the power that we want the government to use. In 2010, the Sex-Discrimination Act was combined with all the other discrimination legislation in a new consolidating act, the Equality Act. Existing exceptions for occupational requirements and sport were carried over. The Equality Act extended protection from gender reassignment discrimination to service provision. That meant there had to be a new exception for single-sex services to cater for the situations where there's good reason to discriminate on grounds of gender reassignment in service provision. It also made good the lack of any permission to exclude people with GRCs from lawfully sex-restricted posts. So it solved the bra fitter problem that I mentioned just now. But no specific exceptions were added for schools, colleges, charities and associations. All in all, it's not a well-thought-through act. It's buggy in numerous ways. That many of which are not at all about gender recognition or sex. But in particular, it failed to address the hard questions about how exactly the Gender Recognition Act interacts with the protected characteristics under the Equality Act. Ever since then, even equality law experts have been unable to say with certainty how the two interact. The Equality and Human Rights Commission said that in 2018, and the Employment Lawyers Association set out two quite different cases and admitted that it couldn't. I was a party to the drafting of that. We admitted that we couldn't agree between us on what the correct interpretation was. In 2019, Judge James Taylor in the Employment Tribunal in Maya Forstater's case said that if someone has a GRC, that means other people have to treat them for all purposes as if they've changed sex. That, of course, is the fallacy that I alluded to earlier. Discrimination law has no business dealing with interfering in how we treat each other socially. So that couldn't be right. That disregarded other people's rights and interests and was obviously wrong. Mr. Justice Chowdhury set matters straight when the matter came to the Employment Appeal Tribunal in 2021, not, I think, to the surprise of anyone who understood the law in this respect, or understood those bits of the law that were capable of being understood. At the end of last year, in the For Women Scotland case, Lady Haldane ruled that a gender recognition certificate changes a person's sex for the purposes of the Equality Act. Her reasoning in that judgment follows a conventionally literal approach to statutory interpretation. It probably reflects what most lawyers, certainly most lawyers looking at this afresh, would think. It's certainly what I thought until about a year ago. But what Lady Haldane didn't do was grapple sufficiently with the human rights violations or the many nonsenses that are caused by literal interpretation. And if you think hard enough about those, our view is that there is only one acceptable conclusion. So we think she got it wrong. A gender recognition certificate doesn't change somebody's sex in reality. It doesn't change their human rights. It's very unlikely to change. No, it's not unlikely. It's inconceivable that it could change their vulnerability to sex discrimination either in itself. And especially for women, the consequences of maternity or the possibility of maternity. The truth is that in any imaginable concrete situation in which it's justifiable to treat a trans person without a GRC in a particular way, it's also going to be justifiable to treat a trans person with a GRC in the same way. A certificate makes precisely no difference to the practicalities or the interests of other people. And that's especially obviously so when you consider that in most cases, the other people concerned won't and can't know about the existence of the gender recognition certificate. So the Haldane judgment may be appealed and overturned, but that in itself is only considering one narrow aspect of the Equality Act. It's quite specific to provisions about increasing representation of women on boards. So we think that these fundamental questions about how the two pieces of legislation work together or ought to work together need to be considered and determined by Parliament. So that's the moment for me to hand back to Maya to finish talking about the amendment, how we think that ought to work.
Thank you, Naomi. So the amendment does one simple thing, which is to sort out the category in relation to sex discrimination. So it makes clear that a woman includes a woman who identifies as a woman who identifies as a man, a woman who identifies as non-binary. Anyone who's female is included in the category woman. And similarly, anyone who is male is included in the category man, however they identify. It doesn't take away anybody's rights. It doesn't change anybody's rights because it can't. Those human rights are indivisible and unalienable. What it does is it sorts out the categories, and that makes it easier to consider what's fair to do when there is a conflict between two different people's rights or the rights of two different groups. And it makes it easier and clearer to communicate clear sex-based rules when those are needed. In practice, the Equality Act doesn't require service providers to do things in a particular way. It remains up to service providers and employers to make sure that they respect everyone's human rights and for courts to decide if they're not doing it. So we have a couple of slides where we sort of try to show how this concept of balance of rights applies. And so that you can see how this works with clear categories and why we say a GRC doesn't change the situation, doesn't change what's fair, and doesn't change people's human rights. So this one is the situation in the Goodwin case. Christine Goodwin didn't, when going to the bank or getting insurance, didn't want to anyone to see or didn't want to say, I'm male, I don't want to talk about it. And the person on the other side representing the bank says, I'd like to know if you're male or female. So the two different rights that are in conflict on one hand is Article 10, freedom of expression, which includes the right to receive information, and on the other side, Article 8, the right to privacy. And these two often come into conflict whenever there's a piece of information that someone wants to keep private and someone else wants to know about it. And in the European Court of Human Rights, they said that in this case at the bank, for a interaction that is not a deeply personal interaction, there was the right of Christine Goodwin to keep his sex private was more important than the right of someone else in the bank to know his sex in that particular situation. And that balance of human rights applies whether Christine Goodwin had a gender recognition certificate or not. The gender recognition certificate doesn't change the underlying rights. What it does is it provides a means of securing that privacy, because it changes what it says on paper. So it secures the privacy of that information. But it's a very analog solution to this. There could have been other ways of solving this particular relatively small, relatively trivial example of trying to keep a piece of information private. The bank could have done it by not showing people's sex on the screen that most bank employees see most of the time, when they don't necessarily need to know that person's sex, for example. And then this is another example, one that I think we've all thought about quite a lot, where a trans person is saying, I'd like to undress with members of the opposite sex, and I'd like them to pretend that I'm the opposite sex. And the right that they're exerting there is Article 8, their right to privacy and identity, and Article 10, their right to freedom of expression. But on the other side, there's the right of those people who are expecting to be able to change in privacy and dignity in a single sex space, and they have rights too, and including Article 3, the right against torture and humiliating treatment, which includes not being forced to strip in front of members of the opposite sex, but also Article 8, their privacy, Article 9, their freedom to believe that a man is male, and Article 10, their freedom to say so. And in practice, it's impossible to put these two people into the same room with their clothes off and respect both of their human rights. So it's perfectly legitimate for the service provider to say, no, this space is single sex, it's female only, but we will also think about how we include people for whom single sex spaces are not, don't make them feel comfortable. And, a unisex option is often available. But again, this question about the balance of human rights on both sides is not changed by the person having a gender recognition certificate. And in fact, the gender recognition certificate is completely irrelevant. So, and the service provider can't be expected to make these kinds of decisions about human rights on a case-by-case basis, faced by two individuals in front of them. What they need to be able to do is have policies and rules that are clear and that are communicated. So that means in order to develop those policies, they need to be able to think about who the groups of people are who are affected by them. And so they need to be able to think about men and women are two separate groups, and people with with the protected characteristic of gender reassignment are a different group from people without that. So, as we said, a trans woman is a man with the protected characteristic of gender reassignment. And that material reality doesn't change whether somebody has a gender recognition certificate or not. So, going back to the test that we set ourselves, we think that this amendment protects everyone's human rights. It's based in their human rights. It's politically feasible. It can be done with a statutory instrument under the powers provided by the Gender Recognition Act. We think it will go a significant way to solving the problem because it will clarify what the protected characteristics are and then allow for judgments and policies to be clear about the two sexes. And it simplifies, it makes it clearer to understand what the law says and to communicate it. As I said, it doesn't solve all the problems, and it leaves the Gender Recognition Act in place. And the particular problem with the Gender Recognition Act that it would leave in place is Section 22, the part of the Gender Recognition Act that makes it a criminal act for someone to share information about a person's sex that they've received in an official capacity. And that's an issue that then needs to be tackled with a different set of amendments. But it gets us a long way up the board, and then we roll the dice again. And so we considered, we've had lots of questions and comments from people, and we really appreciate them. And it's been very helpful in sort of thinking this through. And we've considered what the other options are. We don't think that it's politically feasible to repeal the Gender Recognition Act at this point. And we think if the Gender Recognition Act is to be repealed, it has to be done by securing the human rights of transgender people that led to the passing of the Gender Recognition Act. We have to find another way of securing those rights, understanding what those rights are, understanding that they're limited and that they can be protected in other ways. But we don't think that that's politically feasible right at this point. There's been some suggestion about removing gender recognition as a protected characteristic from the Equality Act. I think there's a danger in doing that, and the danger is that we will return to the situation where people are trying to bring sex discrimination cases because of gender reassignment, and that's what's happened in the US, where they don't have a separate protected characteristic with its own exceptions. The Equality and Human Rights Commission's approach is you just need more exceptions in the Equality Act. So where there are exceptions for single-sex services, they think, well, there should be, or perhaps some people at the Equality and Human Rights Commission think that there should be another exception for schools and another exception for charities, another exception for associations. But then you get into a situation where you're saying that a gender recognition certificate changes sex for all purposes in the Equality Act, apart from all the places where sex matters. And that just seems like a crazy way of going about something that will not simplify the law and make it easy to understand, but just make it harder for everybody. And then there's been the suggestion that you could separate out and say that a gender recognition certificate changes a person's gender, but not their sex. And that doesn't work in law, and it doesn't work practically, because the words male and female, man and woman mean sex. And sometimes we say gender, but it doesn't mean something different. So we've considered all of those options, and we think that the best way to do this is to focus on reality and focus on rights, and that's what this amendment does.
Well, thank you so much, both of you. I think that was incredibly enlightening. We have time for a few questions, and we'll try and keep the answers as short as we can. But actually, most of the things that have come in the Q&A, I think, have been answered in during the session. Naomi, perhaps I could start with you. I mean, the Equalities Office did respond to us after 10,000 signatures and say there was no need for this amendment, and that letter has gone out to everybody who had signed the petition by that point. What were they doing? What were they talking about there?
I'm sorry, say that again. I was momentarily distracted.
So at 10,000 signatures, we got a response from the Equalities Office, and in it they said, they said that there was no need for this, that single-sex spaces were already covered. What was that about?
Yes. The fundamental problem, and that goes back to the Haldane interpretation, the Haldane interpretation means that a gender recognition certificate changes the comparator that you use when you test for gender reassignment discrimination. So it's still possible to exclude people with a gender recognition certificate in most of the situations where you would need to exclude a man from a women's space or vice versa. But it makes it more complicated. So if you exclude a man without a gender recognition certificate from the women's changing room, that's sex discrimination. It's straightforward. It's allowed because you're allowed to run a women-only changing room. But if you exclude a man with a GRC, and Haldane stands, what you're doing is excluding a woman on grounds of gender reassignment. And then you have to justify that separately from the justification that allows you to run a single-sex service in the first place. And that just leaves service providers in a very unsatisfactory position. It leaves them having to decide, possibly policy by policy, possibly case individual by individual, but it makes it much more complicated and difficult for them to know what it is that they're allowed to do and when they're allowed to do it. If we simply say sex in the Equality Act always means biological sex, or words to that effect, then all those difficulties are swept aside, and anytime you're allowed to discriminate on grounds of sex, you're allowed to discriminate on grounds of biological sex. So it's much easier, and that means service providers can communicate clearly and their users can understand what they mean and can be sure that when they say this is women only, it really is women only. It makes it much harder.
Maya, I might bring you in here to talk a little about the Lesbians Without Liberty report, which I think touches on other aspects of the failures of that answer.
Yes, yeah. So when we talk about this, everyone jumps to the exceptions, the single-sex service exceptions, but there are other exceptions or other situations in the Equality Act where you will want to do something that's single-sex. So schools, charities, associations, which means formal clubs of more than 25 people. So probably not your book group, but potentially if you have a big online book group, for example, or a membership club or any kind of trade union or a membership organisation, all of those are places where the Equality Act, on the face of it, allows you to have a single-sex association, a single-sex charity, like Guides, like Women's Refuges, and single-sex associations like a club for lesbians or a club for gay people, a gay men association. And there are no exceptions in the Equality Act that allow for discrimination on the basis of gender reassignment in that situation. And the Equality Act only considers people with the characteristic to have a protected characteristic, not people without it. So there's really no way of specifying that this is an association for lesbians, and by that we mean actual female lesbians. So, and this was recognised in the Section 35 order, where the government stopped the passage of self-ID in Scotland. They said there are existing problems with the Equality Act, including this impact on associations, on schools, on higher education institutions like women's colleges, and on charities. And none of that's answered in the answer that we got from the government after 10,000 signatures. They only focused on the single-sex services exceptions, which do exist, but as Naomi said, are more complicated than they need to be.
I'm going to stay with you now, Maya, because an interesting question has come in. People often say, how come birth certs can be changed, their historical record? And you used an intriguing word in your section of the slideshow where you said it's an analogue solution. So is there a way we could just do this better without falsifying things?
Yeah, so a birth certificate is a certified copy of your entry in the birth register, and it's the birth register which is a historic document. And when someone gets a gender recognition certificate, it doesn't actually change their sex as recorded in the birth register. What it does is they get a entry in another register that sits alongside it, which is the gender recognition register. But then what happens is when you get the birth certificate, you're given a copy of the entry into the gender recognition register in a way that doesn't show that this is not a copy of the historic record in the birth register. It's a copy from this other register. And they did that copying what happens with adoption. But what happens with adoption is if a child is adopted, their name is changed, for example, you can't see that they're adopted on their short form birth certificate, but the long form adoption certificate of adoption shows that it is an adoption certificate. It doesn't rewrite history. It allows the child and the parents to keep the fact of their adoption private for when they don't want to explain it to all and sundry, but it doesn't try to completely hide it and rewrite history. So it thinks about how you keep information private, but also how you keep it true. And you could do something similar with the birth certificates and gender recognition, which is to allow people to have a short form birth certificate which doesn't show their sex at all. And when your birth certificate is not like your passport or your driving license. You can have as many copies of your birth certificate as you want, and other people can have as many copies of your birth certificate as they want. They just go and apply for it. So you could have a copy of your birth certificate that has your sex on it for when you need to show your sex to a doctor or something, and you could have a copy that doesn't show your sex on it. And that doesn't mean that you have any kind of special status. It doesn't mean that you don't have a sex. It just means that you have a piece of paper that this piece of paper doesn't show your sex. Similarly, your short form birth certificate doesn't show your parents on it. That doesn't mean you don't have parents. It just means that that's a piece of paper that doesn't show that particular piece of information on. So, and they thought about doing that at the time of the Gender Recognition Act, but the only people that they were really listening to were Press for Change and the trans rights activists, and they didn't go with that approach. They could have done. And now, with so much information is digitized, all of those pieces of information can be kept separate anyway and not shared when they don't need to be shared. So it would be quite easy when Christine Goodwin now gets an insurance policy. One, they're probably not going to the bank and doing it over the counter anyway. They're doing it online. And two, they're not necessarily showing an analog birth certificate. What they're showing is a digital set of information that's needed for that particular setting. And if in that particular setting no one needs to know your sex, you just don't reveal it. But in another situation, like registering for the doctor, getting married, trying to use a single sex service, that piece of information is needed and it should be accurate.
Excellent, thank you. So a couple of people have asked about DSDs. Our proposal doesn't do anything to change the way DSDs are treated. They aren't something that's done via the Gender Recognition Act anyway. People with DSDs, they're medical conditions, so disorders or differences of sex development. The way they're treated now is the way they would continue to be treated. But I'm going to ask Naomi probably our last question for the evening, which is about non-binary identities. We haven't mentioned this even at any point during the conversation, but of course this is the next frontier, recognising non-binary identities. Should we be doing something with this? Does this fit into our framework? What's going on?
This is something that simply doesn't need any special treatment at all. People who identify themselves as non-binary have exactly the same human rights as everyone else. They shouldn't be discriminated against in relation to their human rights because of being non-binary. That probably is another other status for the purposes of human rights, the convention. There's doubt about whether the Equality Act already protects them under the protected characteristic of gender reassignment. As most listeners probably know, there's been a non-binding first instance judgment of an employment tribunal that has been suggested it's been suggested that gives recognition to non-binary status as part of that protected characteristic. It's not clear that it does even on its own terms, and anyway, it's not binding. So yes, the short answer is we don't need to do anything special about non-binary status, and it's certainly very far from clear that the law does as things stand now.
Thank you. That was so clear and brief that I'm going to ask Maya to spend about 1 minute telling us something about political parties and the political parties' stance. You said that you want us to try to get this through in the current government. What's our thinking there?
As I said, it can be done with a statutory instrument. It was originally envisaged that the Gender Recognition Act would allow for other acts to be changed if it turned out that there were problems, and it turns out that there are problems. So we think there should be political support for doing this. It protects everyone's rights. The Labour Party have said that they want to protect single-sex services and modernise the Gender Recognition Act. This is also compatible with what they say they want to do. So we think that all the political parties ought to be able to get behind this. It doesn't destroy trans rights. It protects women's rights. It protects the rule of law, and it makes it clear.
Thank you both very much. All right, what I'm going to do now is just take 30 seconds to tell anyone who doesn't know, who's watching this, what Sex Matters does. But first, I'm going to say thank you to both my panellists and goodbye. And I will just tell you what we do with our days. And then we're going to finish with a little video. All right, so Sex Matters is a human rights organisation. We campaign for clarity on sex in law, policy and everyday life. We're based in the UK, we're not for profit, and you can become a supporter. You just sign up on our website. What can you do now if you found what we've talked about here interesting? Well, you can support us. You can donate some money to us. You can sign the petition. Please do keep signing it. It's still open for another few weeks. You can write to your MP. We have a tool on our website which allows you to do that extremely quickly and easily. You just put in where you live and it tells you who your MP is, and then you can put some of your own words in. But very importantly as well, can you keep talking? Tell people what's going on here. Explain to people why this matters. Raise awareness of this issue, because that's how things feed through to politicians. All right, I'm going to say goodbye now, but we're going to finish by showing you a very short video that we made about our petition, and then we'll be signing out. Thank you.